All right, cool. So we're going to get started. Ready? Patrick, is that good? Can we start? Okay. Devin, are we recording?
Given the
double okay. Okay,
there
cool. Hello, everybody, and welcome to Intellectual Property and Video Games from A to Z. I'm going to let the panelists introduce themselves because I don't want to mess it up, and so I'm going to start on my left with Ryan Morrison.
Name one thing in intellectual property that starts with A and then one that starts with a Z.
attribution rights.
Attribution rights. And
Z?
Zed, who is a fellow intellectual property lawyer.
Oh, yeah. Shout out to her. Well played. I am Ryan Morrison of Morrison Rothman. I go by video game attorney on Twitter and Reddit, and I pay Noah.
Yeah, cool. So I'm Noah Downs. I am on Twitter as @mylawyerfriend. I am a cool lawyer because I do gaming law. Hey, what? I said that last year. It worked. I got a chuckle, and I just got a chuckle. And I am employed by this man, and this man taught me.
Okay, and my name is Chris Cotopia. I'm a law professor at the University of Richmond down the way. I teach intellectual property law. I play a lot of video games.
Yes,
I don't know if that helps. And so little knowledge.
Cool.
Not big knowledge, little knowledge.
Yeah. So just for some cred, what's your favorite game?
Farmville.
Oh.
Okay.
That's a good one.
It's Dota, guys. That's his favorite game. How about you?
So I'm playing a lot of Rainbow Six Siege right now.
Okay. I am a big fan of Binding of Isaac. So, good indie games. What's up? Anyway, so we have a lot to talk about. Obviously, intellectual property is a huge subject, and some of you may already know some things, but we want to give kind of a foundation about what intellectual property is. So I'm going to kind of act as moderator because I'm in the middle for some reason, and that just makes sense. He likes to talk, and he's good at talking. So we're going to...
There's some implications there, I think, from that statement.
And so we're going to make sure to keep this panel as entertaining and educational as possible, maybe balancing that somehow.
And as a disclaimer, we are all of your lawyers. This is legal advice.
No.
No?
No.
Oh.
As a disclaimer, we are not yet your lawyers, unless we actually are, because we might have a client in the audience. And this is all for informational purposes only. Please do not take this legal advice and use it, because your situation will almost always be different. So in other words, don't try this legal advice at home. Go to a friend's house.
Boo.
All right, so what is intellectual property, Morrison?
So, listen, jokes aside, you guys showed up here not for bad puns. You showed up here because you saw a lawyer panel, which means you were either streamers, game developers, something else, who knows. And it's important to have a basis and understanding of the industry around you, because the reality is the industry does not care if you make $0 making games as a hobby or $1 billion making games as an evil corporation like EA. It doesn't matter. So you have to understand what a copyright is, what a trademark is, that those are not the same words. You need to understand that if you're making a fan game, you're probably going to go to jail and be tortured. And you need to realize that just because your game is free, you're still absolutely liable under all of the millions of laws that exist. Right. The only other important thing to say up front is up until very recently, meaning kind of the birth of the internet, intellectual property was the land of kings. If you were not very rich, you did not have a trademark. If you were not very rich, you did not care about copyrights. But now that the internet exists, and now that more people can do things from their dorm rooms, all of these intellectual property laws are being re-looked at, re-examined, re-acknowledged in the eyes of, well, this kid making no money still affecting my Pokemon sales at Nintendo, so we're going to destroy his life. Mm-hmm. And that's just important to keep in mind two ways. You guys are all creating stuff. If you're creating stuff, you should be protecting it. Every single open source person I've ever met in the history of my life that, Creative Commons, copyright's the worst, hate it, is that way until they create something and then want to protect it.
Right.
Is that an answer?
That's a great answer, and as you can probably glean from that, he's talking mostly about trademarks and copyrights, because that is kind of what we do a lot of at the firm, and also protecting trade secrets, which is the third of the 4 intellectual property bubbles. We also have the world of patents, which is
exciting.
Where Chris comes in.
So exciting. So patents mainly cover usually kind of physical, functional things, although they can also cover computer software. They are not as a big of a player in the kind of indie market because the main things that you all create are content that would be covered by copyrights, or you might use a trademark to kind of protect the brand name or however you're going to identify it. But patents are big, particularly nowadays on controllers, I think. When we think about kind of the old days, I don't know if anybody remembers when Immersion sued Sony over the DualShock controller, and we wondered why there wasn't DualShock in PlayStation 3, and they said, oh, it's because it interrupts one of our kind of techniques, when really they were hit with a pretty big injunction. And I think now with VR, it's pretty big. I don't really, so this is where I get I don't really know how many indie developers are developing kind of new kind of controllers or physical things, right? But that's something that's important. But copyright and patents actually also play a decent role even in kind of just the software space. They're a little more expensive to get. And so they maybe are still, maybe we'll call them the middle kings, or the, I don't know, the kind of dukes of the development world that kind of play in that space. And a lot of times, if you're on the kind of small end side of it, you're not the target of a patent suit. It's usually somebody a little bit bigger. So it's good to know about them, but certainly not as important as copyrights and trademarks.
Right, and just make sure that we hammer it home. So you got patents, which protects inventions and like innovative works that you've created. You've got trademarks, which protects the source of a good or service. So think about like the McDonald's logo. That's a trademark. But then you also have copyrights, which protect creative expression. And then you have trade secrets, which if you let trade secrets out, then you can't protect them. So you need to protect them through non-disclosure agreements. But we'll get into that in a second. So how do we protect copyrights?
That is a trade secret.
Oh, okay. Well, end of panel.
So copyrights are so fucking simple. And anyone who comes to me to register a copyright, 9 times out of 10, I tell them to go to the copyright website themselves and do it themselves. Save yourself some money, register it. There is very little review process. You click submit, you get copyright.
But you can hire us to do it.
Yeah, sure,
Okay.
and we're super cheap. Trademarks, on the other hand, are something that if you're doing without an attorney, you're asking to not get it done. If you look at LegalZoom, that's the same as throwing your money in a furnace. It's a broken system designed by Satan, and it only deletes your hopes and dreams.
And Robert Shapiro, too.
Yeah. But for real,
OJ
I mean,
fame, if anybody remembers.
and this is true for every area of law. LegalZoom is a terrible service run by terrible people.
Camera's over there if you want to
and
look
I
into it.
dare them to sue me.
Okay, there you go.
But for real, like they're just scumbags. So if you use LegalZoom though, that means something's complicated and you needed help with it. So it's too complicated and you should get a lawyer, or it's not that complicated, you can do the research yourself and save all the money you would have given LegalZoom, but maybe learn it actually what you're filling out and do it the right way. For example, copyrights. You can do research, fill out that form yourself, and get a copyright for $35 rather than pay LegalZoom $300 or us $500, whatever it might be. $35, you can go get a copyright with a little bit of reading. Trademarks, on the other hand, would take you a month to really learn and absorb what you needed to do it correctly. And while you can submit a trademark fairly easily, getting it is the problem. 5% of trademarks that go through LegalZoom or self-filed go through. Meanwhile, even bad trademark attorneys usually have a success rate of about 80 to 85%. So it's a drastic difference. And that's because when you put in a copyright, like I said, there's no review process, you get copyright. When you put in the trademark, you get an examiner who comes to you and says, we want to register this, but, and then 15 pages of legalese that's very scary.
Right.
And most people reading that just say, screw this, I didn't mean to insult Obama, and that's the end of it. But if anyone up here reads it, or the lawyers in the crowd, or even someone who just wants to take the time to sit down and read it all, you realize it's not that scary, and sometimes they just want you to do something as simple as move a comma over in the description that you wrote about what your product is. But that's why you pay us. We work with the examiners, we fix that stuff. And that's kind of the litmus test of when to do your own research versus using us. You know, if you're filing your own LLC, a lot of times you can do that yourself, but you can also go learn how to change your own brakes. And even though it's way more expensive to go to a mechanic, it's just better. They know what they're doing. You don't need to Google it. You don't need to watch a YouTube video and get your jeans dirty. Just, you handle it. But there's truly anything you're doing on LegalZoom is dumb.
So one of the number one questions we get, really, to kind of decide about whether or not you should be doing the homebrew or if you should be working with a lawyer, is what is a copyright versus what is a trademark. So a copyright is the protection. Oh man, I'm gonna mess this one up.
So just say McDonald's stuff.
I'm not going to do that.
All that McDonald's creative content. Is what
Yeah, exactly. Right? So a copyright basically protects, as I've said before, anything that's fixed in a tangible medium of expression, which is a lot of legalese to basically say, if you put it down and it's going to stay at least for a little bit and it's not just fleeting, then you might have a copyrightable interest in it. So if I draw a smiley face, like on this piece of paper, Patrick is going to kill you for taking that up.
No, I'm going to put it back. I ripped the tape very nicely. But even this is copyrighted. Like, if Patrick wrote this, he has a copyright on it. And look how nice the tape will
It's very nice. And since Patrick is employed by MAGFest, actually MAGFest does that. If you're working on something that is like an artistic work, or if you're working on original code for a game, or if you're creating original art assets or music, then you have a copyrightable interest in what you're doing. Now, it really depends on what your employment status is with whoever you're working with if you have a team. For example, if I employ you and you are literally an employee versus an independent contractor, then likely I own your work as a work made for hire. However, if you're an independent contractor that I've hired, I need to make sure that I own your work so that you can't come back later and say, hey, your game really took off, my music was dope, and now I'm going to charge you a lot more, otherwise I want to pull my music from the game.
And then that happens all the time. Games are held hostage by early contractors that didn't sign agreements because contractors own their stuff. Who here is a developer? And who here is working for themselves and not other people? Right. So most people are contracting. Congratulations, that's awesome. Be your own boss.
I'm proud of you.
But most people are contracting to studios, and when you're not signing agreements, I don't think a lot of contractors realize they own what they're making still. It's a real problem for both sides, because you want a contract outlining who owns what as you get more successful, as the money starts coming in, et cetera, et cetera.
Now, on the other hand, if you're out there and you're saying, hey, you know, I drew this really cool logo. I want to protect this logo because it's going to be awesome. It's going to be the next, you know, Assassin's Creed logo. It's going to be iconic. Yes, Assassin's Creed is iconic, okay? Thank you. I get a lot from this guy.
I didn't laugh.
Yes, you did. And so if you want to protect it, you might be saying, okay, well, do I want a copyright? The answer is maybe. But you also want to look more into doing a trademark because you want to protect the source of your goods. Think about it. When I say Castlevania, what do you think of? A particular game or franchise or series, etc. Whatever you want to call it.
The Netflix show.
Was it really?
Anyways.
This makes me want to open up Netflix right now. I didn't even know. Really?
What do you think of Netflix?
Is The Witcher in that one or not in that one? Or?
So anyways, but you think of a particular thing, and it's because the Castlevania franchise has built up a lot of goodwill with that particular name. They've protected that name. And so you immediately think of that as the source of good gaming. I don't know what your opinion is on it, and I'm not trying to throw shade. And so they protect that using a trademark. You can have a trademark that is just the name of something, or you can have a logo, or some combination of the two. The strongest trademark you can typically get is like just your name in black and white letters, because then you can protect almost any single iteration of that name. So you want to talk a little bit more about that?
No, I mean, I think that's, and one of the things with trademarks, a lot of times, you know, you're, what they call it, source identifier, right? What the thing is the most important thing, because the thing you're creating is really cool, right? And so you want to be the one that says that when I say Castlevania, it's this particular game from this particular source or controlled by this particular source. So a lot of times people think of their trademarks as really one of the most valuable assets they have. Now this assumes you own your own company and you're producing it, right? Versus those who are kind of content creators and you're kind of selling your content or your services. Maybe the trademark for what the name of your services are, Bob's Great 8-Bit Art Incorporated or whatever.
I love
Is
that
that a good
name.
one?
That's
I don't
awesome.
know.
Do we have anybody named Bob in the room?
Very good. Bob
Okay,
makes
well,
amazing 8-bit art. Then copyright's the big thing, right? And the one thing with copyright, and I think Ryan mentioned this, is you don't even have to register to get protection, right? Once it's fixed in a tangible medium, so you've put it down on paper, you've put it into the Paint program, you've got a copyright, and you really don't need to register, right? So why would you register? You might want to register because it's really great evidence that it is a copyright copyright that you own. Maybe it's really great because it's really valuable and I can get a loan based on it.
You can also
or I might want to
sue.
sell it to someone, or that's right, sue somebody for it. And so a lot of times copyright registration, and these are the guys in the trenches, isn't something that happens early on. It's usually something that happens a little bit later down the road. While trademark law, it's a little nicer to register the trademark because you can use that registration as kind of a nice proxy to have someone take down a domain name or send something to Twitter and say, wait a minute, this guy's using a handle that looks like mine, whatever.
Yeah.
And that's why registration is a nice little shortcut to kind of protecting that brand.
That's a great segue into what is infringement. So, it's A to Z, so that's the I. There you go. Or it's the N if you spell it wrong. So, infringement. I got a chuckle at least. So what is infringement? Infringement occurs when somebody is out there ripping off someone else's stuff. And if you are wondering if you're infringing something, then the answer is probably yes. And also, if you're saying, wait, but what about fair use? Well, fair use is bullshit. Would you like to elaborate?
No, it's not that it's bullshit. Fair use, you're just all too poor for fair use.
Yeah. You have to, if you were claiming fair use, you got to be sued. It's a defense, not a right.
Yeah. And fair use will cost you at least $250,000 to win in most cases. Because let's be real, I mean, the people you're usually infringing upon are Disney, et cetera, who can cause you $250,000 worth of motion practice and things in a courtroom that will destroy your bank account and all of your investors' bank accounts if you have those. But I get it. I mean, when you're learning to code, when you're learning how to become a programmer, when you're learning how to be an artist, whatever, you go in and you're a fan of Star Wars. So you are learning how to code, you're putting together a game. It is a Star Wars game because you're just doing it for yourself. You're learning, it's fun. Then after a year, whoops, you know how to code. You've figured out how to make a game, but you have this thing you've been working on a year and you're really proud of it. So you want to put it out into the public. We actually see this happen the most with Pokemon. People get really excited about a Pokemon thing they were working on.
So Pokemon's the big one?
Pokemon's the one that it's fun and it's cartoony to learn how to code on. You can make your own
Everybody loves a
characters.
Pikachu.
Yeah, but for real, I mean, and then you say, hey, I've been doing this for a year. I created all this stuff that I think is really cool. Even though it's in this world, I created my own Pokemon, my own whatever. And then you put it up on Reddit, you put it elsewhere, and you're fine, right? You don't get a cease and desist. You don't get anything. But then you put it up somewhere where it hits a little bit of an uptick, it gets a little bit more recognition, or God forbid you charge a cent for it. You're going to get a cease and desist. It's going to come with a full demand for your accounting, and also they're going to come after your house, your car, your kids, and your soul. And you don't want to do that. You didn't mean to get there, but you're there because intellectual property is not something to take lightly. It's a real area of law. These people are very serious about their brands, and most 12-year-olds don't know the difference between your kind of shitty Pokemon game and their Pokemon games. Right. So they just see your stuff and they say, well, all right, this is a Pokemon game. Mom, Dad, buy this for me. Let me download it, whatever. And then they're not going out and buying Pokemon, Sword, Shield, whatever, or they just think the franchise is taking a downturn. And both are just as not okay for you. Yeah. And that's what we see a lot of in indie game space. And it's not just Pokemon, it's everything. But the reality is, if you were asking, is this, and then part two of that is when you go out and you know all this. You came to this panel, you heard Noah speak on his stream, whatever, and you know that.
This is when everyone runs out of the room because they don't want to.
Yeah, exactly. and then you say, all right, I made a Pokemon game. I know I'm going to get sued or I know I'm going to get a takedown. There's no point to release this because it'll never see the light of day. That streamer who's a goddamn idiot that I yell at every year at MAGFest.
Oh, I'm not saying it out loud.
I forget his name, but fuck that guy. The guy who made the video saying, just release it. They can't stop you, man. No. He should go to jail. But anyway, he
should not go to jail.
Should go to Guantanamo Bay.
No.
But so he inspired a lot of people to do just that, release the game and then get in lots of trouble. Also, they can get your game down usually. But part two of that is you say, okay, I have a Pokemon game and Pokemon is obviously infringing, so I'm going to make this into Bob's Retro Animal Adventure Time. And you do a game that is, Pikachu, but he has a hat now. And that's not different
Which is
enough.
actually already in Pokemon Go, like in several iterations, and I have all of them.
When he's a detective, he has a hat, though.
Yeah,
that's right.
Also, there's birthday Pikachu, and there's also Safari Pikachu, and I'm not going down that rabbit hole.
Oh, damn it, I wanted to. It's like Bubba Gump. No one's here. It's old enough for that. But but anyway, the reality is if it's not if it is substantially similar, it is infringing in copyright world. And what that test really means is if your dumbest friend can look at A and see B, it's infringing. The example I use all the time, and then I'll shut up and we can do questions or go whatever you want to do.
Yeah, we got plenty of time.
Yeah, the example I always use though is Jason from Friday the 13th and Michael Myers from Halloween. Both on paper are white guy, hates everyone but virgins, wears a mask that is white and off-putting, uses melee weapons to kill, chases suburban kids that probably have too much money but not enough money to figure out how to call the cops, and like everything else on paper is the same. But if you watch Friday the 13th and you watch Halloween, those are clearly different movies. Those are clearly different characters. They've made, whoever came up with the other one first, made it different enough. Right. And that is what you should keep in mind when you're creating something. Maybe you did learn how to code on a game that is Star Wars themed or Pokemon themed or whatever. As long as you get from Jason to Michael Myers, you're going to be okay for the most part, with a million asterisks that you should talk to an attorney and probably not.
And also, this is a great time to plug, because he said, think about your dumbest friend from high school. We actually have a podcast at the firm called Robot Congress, which will be filming live on Sunday at 11:30. And the premise of that is that Ryan has taken his dumbest friend from high school, who's here at MAGFest, and his name is Austin, and we love him. And we're going to record that episode live, so you'll see that in real life.
Yeah, I thought it was a funny premise to teach my dumbest friend from high school law every week, and it was. It's great.
It's hilarious. It's on everywhere you can download podcasts.
And every review says I'm too mean to him, but I'm not.
You are really mean to him. He's our friend. Anyways, so where was I going from that? So that's what infringement is. And like we said, if you think that you might be infringing, you think somebody's infringing on you, don't look to fair use, because fair use is not going to help. Did we even talk about fair use and all that? We just said it was really expensive. So you want to avoid that kind of stuff.
We'll talk about fair use then.
Well, I don't remember the 4 factors off the top of my head.
Well, you don't need to. I mean, fair use is basically saying, yes, I'm infringing, but it's okay because...
Because it's an educational use, or it's satire.
Or it's so transformative. I mean,
yeah.
So one of the things I think about, like with some of the cosplays you see, where you take a concept and you so turn it on the head, you know, not only have I changed the gender, I've also changed the dress to a different color, and all that could potentially be transformative enough to where, as long as it's not kind of impinging on the kind of commercial kind of revenue of the original creation, you might be in good shape, right? So when we go out there and we see all these great cosplayers, maybe Ubisoft could have a really great copyright infringement claim against some really great R-Jesus, Tanaka and everyone, and say, oh, this is great, right? But does it really impinge on their kind of commercial revenue? They're not selling those kinds of uniforms. And it turns out that this Tanaka has, although this actually is the skin of the game, is a unicorn with a horn and all this kind of stuff, right? But I think that's a potential fair use claim. The problem becomes is if I then make a full game kind of based on that, I then will have kind of concerns. And so kind of what Ryan was saying, I think it's always fun to kind of play in a genre and do some kind of fan fiction or fan kind of homage, which if you walk through the hall of goods down there, it's really full of it, right? And it might make you wonder, why are they not suing all those individuals in that room? Right. They probably could, right?
And if any of you are from those vendors in the room, we're really good lawyers in case you do get that.
But they don't, right? And so I think this is the concern that Ryan's. I mean, you need to be ready, right? If you kind of play in that space of, well, tomorrow they could pull the plug on all of this, right? And fair use will probably not be your friend unless you've really kind of turned the whole thing on its head, and the original creator's not really pushing anything into that space, which nowadays with skins and spin-offs and everyone moving in different markets, it's really tough to say you're not playing in a market where they might be playing.
Right.
I think is the real problem with
And one of the most common ways you see people enforcing their copyrights in this space is through a DMCA notice. So that's one of the most common things you'll see out there. Obviously, you hear about cease and desists all the time, but that might not necessarily be the first thing that you receive. So what you would receive is something called a DMCA notice, which is filed under the requirements of the Digital Millennium Copyright Act, which you will never remember because you'll just hear DMCA. And so under the DMCA has provided a lot of safe harbors for service providers. So think about it this way. YouTube has a lot of videos on it, right? So what if I upload a video to YouTube that is just straight up the first episode of Pokemon ever? I think that was Let's Go Pikachu. Wow, that was bad. And so I upload that to YouTube. If Nintendo or the Pokemon company want to sue to get that taken down, why don't they just sue YouTube? Because YouTube has a lot more money than me. Trust me, I have law school loans. And so why would they not just sue YouTube to get that taken down? They have bigger pockets. Well, the answer is because YouTube is protected by the DMCA. The DMCA creates a safe harbor under which YouTube, if they receive and adhere to the requirements of the DMCA, is safe from basically a lawsuit. And that is because YouTube has something called a DMCA policy, where if the Pokemon company comes up and says, hey, that video is ours and here's proof, they have to submit something under penalty of perjury saying that they own the copyrights in that video. And then YouTube says, okay, we've received this notice, we're gonna take this video down. And that's what a DMCA notice is essentially. It's an automated way to take videos down that infringe upon copyrights. So you see this abused a lot, and we're gonna get a question about that towards the end of this. I know it, because it happens every time. So what do you do if you receive a DMCA notice and you do own that content? Well, the first thing is to check and make sure you own that content, because you might not. Because you might think you own it, but you don't, because fair use is not a thing.
Well, it's not even that. I mean, we had a very popular YouTuber who used, with permission of the band, one of their songs as his outro music for a decade. Since the inception of YouTube, he was doing it. It's one of the biggest YouTubers around. And very recently, he got over 700 takedowns on his videos. And he had a Facebook Messenger approval from the band from 10 years ago saying it was okay. But in reality, the band didn't own its music rights. The record label did. And the record label caught wind of his channel and took everything down. And that sucks. There goes his whole channel. Intellectual property is really complicated. That's why people pay lawyers to do this, because just because you made something doesn't mean you own it. Depends where you worked at the time, depends what teams you were on, what contracts were in place, and how many times that's changed 100 times over. Look at how many people are trying to create retro games again, and they think because the trademark abandoned that they can go out and make the game.
Oh, talk about the skate thing.
Sure. That's another really good example. If you look, I think it was Kotaku was at fault. Yeah. But there was an article very recently on, hey, Skate 4 trademark is abandoned, so long game. Yep. And it turns out that trademark not only had nothing to do with anything, but the skate trademark is still very alive and healthy. And it's just, people don't understand this stuff. So the entire internet created the hashtag Save Skate 4, whatever it was going on. And it was unnecessary, ridiculous, and just silly. There was never any indication that any studio did anything different with skate. But that's intellectual property. That's IP. That's why this stuff is so scary and strange. And it's important when you are an indie, when you are a creative type, to go out and talk to somebody who understands this stuff. It's not just us, too. I mean, it's hard to find a lawyer that doesn't do free consultations, that can't walk you through this stuff. So even if you hate us, go find a lawyer who will talk to you about this and figure it out.
But we do offer free consultations.
Yeah, but I'm very busy. No, I'm kidding.
I'm not.
I'm not.
Yeah. He's my boss.
Yeah, watch his promotions over there.
So yeah, no, and so there are a few other things that you can see, kind of circling back to close up the DMCA. Is that okay if I finish?
Yeah, do you ever think about that though? Like the guy, if you go on YouTube right now, you can find the kissing scene from Wayne's World, right?
Yeah.
But the Universal, who owns that movie, has teams of people just sending out takedowns all day. That means there's a guy somewhere who just sits in his house and re-uploads that every day.
Some people have trust funds.
Same guy.
And, yeah, he's like, hey, sorry, Ted, I can't come out tonight. I gotta re-upload this again.
Yeah, but he then loses his account because of the repeat infringers policy. So then he has to re-register with different information. So he has to move to a new address.
Yeah, that's why VPNs exist, just to
master plan to make sure that it's always up there at any single time.
He just creates so many Google accounts.
Yes, he does. He's just got it.
It's
like multi-boxing, right? He's got them all rolling at the same time.
Yeah, you can't use the name John Doe when you create Google and YouTube accounts and things.
You really can't?
No, so our takedown team all uses John Doe. So
I'm on the takedown
there's
team.
an army of John Does out there going around after people, so careful of John Doe. He know not what he do. All right, go on, sorry.
Yeah, no, so one of the things that we commonly...
I guess it's better than John Don't.
Oh,
right?
my God. Anyways,
John Don't's when they really mess up.
so
There we go. See, there we go.
We're-
Nice.
we're almost at the point where we're going to take questions. So I'm going to wrap up this DMCA thing if it kills me. So basically, the end of that is if you find yourself getting into a DMCA war with a company, you can get a ton of them all at once, and they're a great way to lose a lot of your livelihood, because if you respond to a DMCA claiming you own content and you don't, the company either has to drop it or sue you. And so who likes to be sued? Nobody raise your hands. Don't get cute. Okay, good.
But what a gamble, right? Like, what a
Living on it.
terribly written law. If you think that you got an improper DMCA, you need to dare them to sue you,
Right.
or it stays. It's ridiculous. And that's true, and a lawyer's not going to change that for you.
Yeah.
You know, it's really scary to roll the dice there.
Yeah.
And if you're on the other side of this too, it might be your content, right? I mean, if you've created some really great original artwork, original, video, whatever, I mean, DMCA then becomes your friend, right? It allows you to take down, or I mean, a lot of times these providers will also provide, then there might be monetization methods too.
Right.
That's the other alternative that YouTube might give you.
Yeah.
So
The trick that a lot of people figured out was when news is breaking to DMCA all their competition, because by the time the videos get back up, their video is already at the top. And it's not that illegal, but it's super shitty.
Yeah, it's terrible.
Yeah.
So we've talked about trademark, we've talked about patent, we've talked about copyright. The last thing that we want to touch on briefly is trade secrets. And so trade secrets are important because they're really, really hard to protect. Because once your trade secret gets out there into the world, there's no getting it back. There's no other way to protect it. So how do we protect it? Well, we really don't. The best way to do it is to do a non-disclosure agreement. So anytime you're sharing some confidential information, you want to make sure the other person knows it's confidential and signs an agreement to keep it confidential. That said, a non-disclosure agreement is only as good as its enforcement provisions, because at the end of the day, if I go out there, I'm under NDA, and I say, oh, hey, the season 2 of The Witcher has been announced, which it has, that's not breaching NDA, has been announced, it's out there. It's in the world. And so all Netflix can do is enforce some sort of damages provision against me. That said, that's why it's really important to have really strong NDAs, which we build for people at the law firm. That's what I'm supposed to do, right?
I'll just give you those for free.
Yeah. Well, no.
Yeah.
Oh. Fine. Just don't use LegalZoom.
Well, yeah.
Yeah.
You can get one for free, and an NDA is pretty
easy.
I've never met an NDA I won't sign. You're not going to sue me. Just kidding. But for real.
So another thing we want to say is a lot of people out there ask us, hey, what is it like to work with an attorney?
Not like this.
It's not like this.
Okay, seriously, people ask you that question.
No joke, they really
What
do.
is it like?
What's
to
it
work
like?
with-
Because people are scared. They're like,
Sounds like
it's
a
going to cost me $1 million.
Match.com question,
Well,
right?
one of the things that I often get is people, this is related, guys, okay? I'm good at this. Is because people ask me to sign an NDA when they're hiring me on as their lawyer. You don't really need to do that, because what you tell me in anticipation of representation is protected by attorney-client privilege, which is stronger than any NDA that you can have us sign.
Right. Just ask Giuliani. He knows.
Anticipation of representation is a good band name.
Yeah, it is, but it's probably already trademarked. Anyways, so that said, talk to a lawyer, get your consult done, make sure that you're protecting your stuff, because you want to protect your intellectual property, because it's what you have, it's what you monetize, it's how you start working for yourself, like that guy, is because you're going to build your own IP.
Also, I know that half this room
He's
is...
feeling the pressure, actually.
Yeah.
We need to stop that.
Yo, all our hopes are riding on you.
No,
If it flames out, he's going to come back to you and say it was this panel.
Most
it was at 6:34 on Thursday that.
No, but I know, listen, and I know we work in the game space, and I know that half this room is too socially awkward to call anyone on the phone. If they want a pizza, they'd rather starve to death. So, like, email us, instant messenger someone, but talk to someone who understands this stuff. And not only are you going to get legal advice, but you'll get good business advice oftentimes as well, because your idea can be the best idea in the world, but if it's not properly protected, if you don't have someone on your team who can go talk to investors or market your game, it's not going to go anywhere. And you need to work with a whole team and a crew to do that. But really, don't be afraid to talk to people in this space. It is intimidating to call anybody in 2020 now. But get over it and call a lawyer.
Yeah. So without further ado, we're going to open up the floor for some questions. And we have a hot mic on that side, I think.
Speaking of nervousness, come public speak into a microphone, you assholes.
Yeah. So by the way, just kind of come up here or something. We'll hand you a mic. Can you get it off there?
I can certainly.
Yeah, it's fine. Just stand in the middle where everyone can see you and hear you. It's a really short mic.
Well, it's a small room. Why don't we just shout?
We'll just project. You can put the mic back up here, actually.
It was fun. That whole process was fun.
And look, it says we have to repeat the question. So
okay, we'll repeat the question.
So you talked about copyright infringement. How far off? Let's say I'm a 3D modeler and I love a certain genre or whatever, blah blah blah, and I make a really cool model that's a version of that. How far off do I need to be to not get a C and D and it be considered a derivative work?
Okay, so the question is, if he's a 3D modeler, allegedly, because you sound like a 3D modeler. No, just kidding. Yeah. And so if he's a 3D modeler, how different does something have to be from the original work to be considered different enough? This is actually a really great question when it comes to 3D modeling in games like, what is that game? Anyways.
What is that game?
Extra Life? No.
That's a charity.
Second Life. There you go. Where you're creating 3D
Second
things, and
Life.
also in the 3D printing world. We have a lot of 3D
dollars. You cashed out on those,
Yeah,
didn't you? You made
exactly.
a ton.
And
he had
Master
millions
Chief,
and
we're
millions
getting
of
the hell outta
Linden
here.
dollars. He was.
All right, I'm going to answer
He
the
owned
question.
like a whole island on there too, didn't you? I
He
think.
did, but nothing else. And so the question is, how do you make it different enough? Well, there's actually an entire sub-market of the world. It's a black market that creates 3D printed auto parts. It's costing the auto industry like $1.3 billion a year. And so this came up there. I was at a U.S. Patent and Trademark Office talk on this, actually. It was pretty cool. So the answer is, if you're trying to make it work to work with specific things, you're trying to create something that is different enough, that is probably not going to work at all. So if you're trying to create a 3D printed Pikachu, it's going to be a Pikachu. It's a rat that has an electric tail and cheeks. Okay. So you can't get but so different from it. So the way you should really approach it is create some original work and then see, if it's close to something. But try and create the original stuff, but there's no really way to say this is too different from. We can give you a legal opinion on it, but you have to pay us for that.
Yeah, I mean, it's what I said earlier. If I can look at your thing and see the original inspiration, it's too close.
Yeah.
So the other thing is that, quite frankly, derivative works are part of the exclusive right of the copyright creator, right? So if I create a Pikachu, I actually also get a right to exclusivity over derivative work. So if I take Pikachu and make him blue or green or big or small or I don't know, whatever you would do with Pikachu, it's actually in
Put a hat on him.
the creator's hands.
He actually has quite a few hats.
Yeah, a
that's right.
safari hat. He's got like a little thing for Halloween that they did this year.
Copyright's really broad. It's a nasty beast, quite
Yeah.
frankly, unless you're on the other side, and then it's your friend, right?
Yeah.
I think that's the deal.
Yeah.
So
What's really fun though is you own your infringing stuff. Which is really relevant for MAGFest. So if you go down and you see the fan art booths or the whatever merch stores here, if let's say you made a Pikachu shirt and you drew it, and Nintendo, or more accurately the Pokemon company, came down and said, hey, take that down, also we're going to start selling it. No, they can't do that. You own your infringing stuff.
because you've made something fixed in a tangible medium of expression, so you have a copyrightable interest in your infringing
But
work.
you can't sell it because it's infringing, but they
Right.
can't sell it without your permission either.
So could you license it?
Sure, and
You
that
could.
happens all the time, but more accurately what happens is they sue you or send a cease and desist, and you give them that license for free, so they stop.
Yeah.
But technically you don't have to.
It does happen though. I mean, there's a lot of times. I mean, you've probably seen examples where fan art then becomes the skin or the
Right. Totally.
or the level or whatever. It's just a very tough way to leverage into it. Although I can think of actually a lot of designers that have gotten onto teams because they were the best Dota 2 map creator
Absolutely.
or something, right?
Yeah,
Actually, Dota is an example of. Right, the Age of the Ancients was this kind. I mean, that was that was the beginning of this.
When the NDAs stop, or when people get closer to their deathbeds and just start talking anyway, the lawsuit and settlement between Blizzard, Valve, and Riot is the most interesting intellectual property thing that's ever happened in video games.
Fascinating.
Between Heroes of the Storm, Dota 2, and League of Legends, it is the best.
Cool.
But you'll have to give me 2 whiskeys to tell more about it. Just
At
kidding.
least 2. All right. You walked up here because you have a question. I can tell.
I do. And I'll use the mic because I'm not afraid.
All right, cool.
Nice.
See,
I like those.
uses the mic.
You can only run so many conventions before you get used to public speaking. So, question. I created a convention called BronyCon back in the day. And
What is it
after that, BronyCon, the My Little Pony convention. Then I created a cruising group called Sea Bronies. We have a mascot. It is a My Little Pony character, but it is not a Hasbro My Little Pony character. Sometimes when I go to get materials printed, like come on a cruise with us, and they'll say, oh, we can't print this. This is a My Little Pony character. And I say, this is not a Hasbro My Little Pony. This is an original character. What is the legal standing of OCs?
Well, so before you answer, because I saw you almost want to, I have to tell you
I was about to say this.
that we are not allowed to give specific legal advice to specific questions. I can say generally, though, about original characters, there's not one on Earth that's not infringing. So this happens a lot in My Little Pony. It happens a lot in Sonic. Every one of those characters is 100% infringing. And they allow it to exist, but if they are asserting rights elsewhere, or if the studios are uncomfortable with it or whatever it might be, that's well within the reason of copyright law, because it is a derivative work created in a universe meant to look like something and meant to evoke memory of another
In
work.
the style of
kind of so it's not the answer you want. It's unfortunate, but it is definitely, it's pretty black and white.
Basically, as long as Hasbro doesn't come stomping on me, it's like I'm just at their mercy.
You are at their mercy, right?
You're at their mercy, yeah. Good luck, Godspeed, may the force be with you. Yeah. All right. Thor lookalike.
I was wondering if you could talk a bit about international copyright and just why that's more difficult.
Sure.
So the question is, international copyright. Why is it more difficult? Is it more difficult?
I mean, the answer is yes and no. It's really not that much more difficult. Same with trademark. We have different treaties with many different countries, and one of the main treaties around controls different ones, controls copyright and trademark, and most Western, it's not even Western, most countries on Earth are under the Madrid Protocol.
So the Berne the Madrid Protocol is the trademark, but the Berne Convention, and actually we were the slowest to kind of adopt it.
Well, Canada.
Oh, okay.
It was like
There's
like
this
a
country to the north
slow
called
burn.
Canada. But they're very low formalities. So just like we were talking about the fact that you don't have to register in the United States to get protection, that was actually the norm in Western Europe, et cetera. So really, you're going to get protection. The harder part is going to be about enforcement. What's the mechanism for enforcement? The other thing, and these guys have much better feel this than I do. I think the international side is high stakes, high cost.
Yeah,
for sure.
There's this small little market called the United States that we might still have dollars to spend. I'm not really sure, but and I always think that that's where you want to start with, right? But the other thing, if you think about it, like most of the distributive mechanisms are all in the United States, right? So, I really don't like the fact that they have a game exactly like mine. Well, guess what's based here? There's this thing in Mountain View, California called Google, and they run the Google Play Store. And then there's the Apple iTunes Store. And I've got all these nice choke points in the U.S. to stop distribution. And I can do enough damage, I guess, is the best way about it. But I don't know, it might turn out that your game's popular in Estonia like Hasselhoff's popular in Germany or something, right? And then you hire that attorney that really knows how to go about it.
And one of the things we often hear about kind of tangentially with that is when it comes to international stuff is, well, I'm international, so where is this going to be enforced? And actually, a lot of times that's solved in a contract. You'll find that most of you are signing contracts based in the United States. For example, Twitch partner contracts, or as they call them, content license agreements, are all effective in California. So that is where you would have to take care of all that stuff. So international is important, but for the large part, you're going to end up doing it mostly in the United States.
And it's also the same answer. I mean, copyright is cheap most places and trademarks expensive most places. The nice thing is the EU is one trademark. America is one trademark, despite us being 50 states. Any lawyer trying to sell you a state trademark, you should run away from. We do have state trademarks, but they are utterly and intrinsically useless.
Unless you get like 50 of them.
Sorry, no one loves state trade. No, I'm kidding.
I hate state trademarks.
No, but really, I mean, like, we have federal trademarks here that are insanely powerful, and you should be going after those, save for the most rare circumstances. And then in terms of international, we very commonly file copyright and trademark in the EU, and unfortunately now you'll have to do England separately.
Well, no, so I'll actually say, post Brexit, the EU will stay with the EU trade. They will.
Really?
I was.
Oh, is that
at
true?
a conference,
England
I was at
stay
a
there?
conference with some of the people from the UK. The patent side's going to be a little bit of a different issue, but they think with the trademark side, you could still file, but they're going to try to keep the treaty to make it.
That's good to know, because they know they're going to fix it once they get a rational person in office. It's like us just all pretending Trump's not there. Like, no, these laws he's doing, that's a joke, guys. We'll be back in a couple years. Yeah.
So, but the one thing that Noah mentioned, I think that's important, I know we're talking about intellectual property law, but quite frankly, the big thing that plays in this space is this thing called private law, contract law. I mean, these end-user licensing agreements, a lot of this is two parties making up what the law is that they want the law to be, the open source license agreement, whatever it is. And I think a lot of times people think of those as separate from intellectual property law, but quite frankly, they usually are the more pernicious of the two, and can get you a lot or take a lot even more away from you than copyright law would potentially do. So always look at the contract that you quickly scrolled through and clicked okay.
Exactly.
And make your own when you are releasing something.
But don't go to LegalZoom.
No, definitely don't. But if you Google CCPA while we're talking about it, California just put in a law that's even more overbearing than the European one. So now privacy policies are really serious. Even if you're just tracking an email list from your users, you're liable for pretty major fines right now. And unfortunately, we cannot say who, but just judging on size, they're going after indies and mid-size. They're really trying to prove a point, and they're hitting everybody real hard.
They're hitting a couple of indies really, really hard.
And that's
life-ruining. Yeah.
It's big because you think about how many games are online, you sign up for it, software as a service, and now you're starting to store all this crap, not crap, really nice information about your users, John Doe and John Doe, right?
John Doe.
John Doe? Sounds like a Star Wars character. John Doe. Anyway, I broke Chris. But yeah, so pay attention to CCPA. Some of you might think I'm talking about like something to do with Soviet Russia, but I'm not. And
pay attention to them too, though.
They're pay attention to Russia. Why? Anyways, so next question. All right, you in the back.
Okay, so as probably most people here know, publishers for video games own the intellectual property rights as opposed to traditional sports where the NBA does not own basketball. So I'm wondering where we see the publishers going with enforcing the use of their intellectual property as esports gets more popular over the next few years, and how enforcement will manifest.
Cool. So the question is, publishers of popular games such as Overwatch. Are you wearing an Overwatch jacket right now? Yeah, okay, cool, that makes sense. So publishers of professional games such as Overwatch have the Overwatch League where they own all the assets relating to that game, as opposed to traditional sports where that's just not true. So how is that going to change? Finish that for me.
How is it going to impact if they decide to enforce it with third-party companies?
Gotcha. So how is that going to impact enforcement on third-party companies that are making things for those games and merchandise?
We deal with this all the time.
Every day.
So if there is an indie studio or a studio that's a little more loose with its licensing or where it lets people go, not such an issue. and shockingly, Nintendo is one of the friendliest with this, despite what people really like to believe and yell. But look at how many unlicensed Smash Brother tournaments there are. Look at Project M, which I still lovingly, I don't know if half the team's here, but I work with them. Still, I'm the name on their website if you want to sue them. They were one of the most popular Smash Brothers games around, and sure, they've been mostly dealt with and pushed into the shadows, but you can very easily go find a Project M tournament still. So Nintendo gets a really bad rap, I think undeservedly so. But that said, looking at Overwatch, looking at League of Legends, looking at Dota, et cetera, they all do it very differently. If you look at Blizzard, who does Activision Blizzard, which is Call of Duty, Overwatch, even Heroes of the Storm, etc., if you want to go put on your own tournament at a LAN center, you have a really hard time to do that. There's been a lot of small brands that wanted to go out and try to do it. Red Bull very famously advertised and then took down an Overwatch tournament that they were going to do for, I believe, it's been a while, I don't know, it was years, but whatever it was got stopped because I think it was Red Bull, maybe it was Monster and vice versa.
Monster, yeah.
Whatever it was, one of the companies wound up sponsoring Overwatch leagues, so none of the other drink companies were allowed to touch it. And that's a power that the NFL doesn't have. If Vince McMahon wants to start the XFL, he's allowed to. He's even apparently allowed to go steal Monte Cristo's logo and start his own Dallas team with it, which is hilarious. But anyway, looking at Valve, on the other hand, it's the complete opposite thing. I don't think Valve knows they have games. You can go put on a Dota tournament wherever you want. Yeah, right. And I will tell you
There's
this:
this thing called Steam, a broken a browser that you go through. And
I will truly say though, if an attorney from Valve ever winds up in your inbox or calls you, just shut it down what you're doing and beg forgiveness and run, because those guys don't come out of the shadows unless it's on. Blizzard, on the other hand, Activision, they're friendly, love that legal team, super friendly people. And Riot is very similar in the sense that they have the biggest esport in the world. They're putting out all these new titles. I think they're going to try, from rumors around the industry, to be a little more friendly with localized tournaments and letting people bring a little gusto to their communities. But I'll believe that also when I see it. Valve proved they don't need to run their own tournaments. ESL and everyone else will. Activision, Blizzard, and Riot have always done everything themselves, and I don't see that changing.
The one thing I'll say that I think that's interesting when you think of those two models is, again, not to expand this panel even further, but digital rights management, self-help is another way to protect your IP, right? So one of the ways that Blizzard's able to, from the bad old days of BNetD, is the way they were trying to lock down people from doing things that they didn't want them to do them, is to lock down the servers to start things up. We think of the old WoW Classics, the pre-WoW Classic servers, etc. And so this is another tool you can use if you want to, is if you have it as a software as a service, is you use the centralized control to control when people can or can't run a tournament or not run a tournament. And I think that's one of the big mechanisms that you see at play in these two different models that he's talking about.
All right, next question. That guy that's his own employer.
I just want to say I'm my own employer, but I also have a day job.
I am proud of you either way.
That's the best.
That's how every own employer started. So
that's
congrats.
exactly right.
All right. So what should I be aware of when it comes to protecting original ideas in a game? I guess my concern is, does copyright protect works that are in progress?
I got it. So, yes, it protects the expression of those works. You cannot protect an idea. Hold on. Sir.
This is why he's sat in the front row.
Yeah.
He's ready to roll. Look at he's ready to roll.
So you cannot protect an idea with copyright. You can't protect an idea with trademark either. Get wrecked. So if you want to protect that, you need to make sure you're using confidentiality agreements. You need to make sure that you're locking up anything you're telling people. You need to make sure...
Trade secret is your friend in the development stage.
Yeah, and trade secret, like I said, is like a glass ball that can shatter at any second. So make sure you're starting to express and put those ideas to paper, to work. Make sure you're getting it out there. Because if you are able to start building something, that's much more protectable than the stuff that's in your head. Because we have all had a great idea and then a year later saw somebody else do it and said, man, if only I'd done that. Well, you got no rights. So they did it.
But
good.
I just wanted to say the worst thing Noah and I do by accident on so many panels, and we don't feel this way, is we scare people out of putting their stuff up.
Yeah, we do.
And that's never the intention. So when we say protect your ideas and hide your stuff, it's really important to do that. But you should also be putting up screenshots on Screenshot Saturday. You should also be putting up demos on Reddit, or no one's ever going to see or care about your game. Build the hype. People might steal a mechanic or two. Look at World of Warcraft. Every single successful MMO ever got stripped of its good ideas and put into WoW while they died. That might happen to you. It might not. But you have to just try and get out there, and people will support good products.
And as long as you're making continuous progress, then you're always going to be a step ahead, because anyone who's imitating you is doing just that. They're right behind you. They're not ahead of you. So posting those screenshots is a great way to show later on, hey, I did this at this date, and you did this later on, and therefore I'm going to sue the pants off of you because we've got the attorneys of Morrison Rothman, LLP.
Hello. Also, last I will say, is if you want to talk about things that are patentable in games and everything else, boom, patent attorney. And also probably Andrew in the front row here has written more on patents in video games than anyone in the history of the world. So talk to Andrew too.
That guy.
So I mean, I was thinking patents is something that I think in general they're pricier and the kind of in-game part of it.
They're like $20,000.
Right. But I'll put a plug in for filing what they call a provisional patent application, where you get a year.
Yeah.
And this would be, I think, if your game has a really, what you think of as a novel, the technical terms here are novel and non-obvious mechanic, right? And I have to admit, even just walking through the floor, there were some interesting kind of input devices. Like, maybe that sounds a little bit, but
that's a little weird.
To games that I thought, man, that's something that maybe I would have thought, right? Or a gameplay mechanic, because the potential purchase, in a sense of the scope of protection, could be pretty big. If you're a small entity, it's a $130 filing fee. You will need to hire an attorney to do that. I mean, this is one where you will need to get involved with one, and probably let's layer another $1,000 on that. But it puts a stick in the ground, and you've got a year. But I think it has to be that you've got something. You go, look, no one's ever. You're not thinking about a mechanic like World of Warcraft. I mean, you've got something that's really whiz-bang. I mean, the nice thing about copyright is that you can put those screenshots up there, and they're protectable, right? And then you can use trade secret to at least protect the code that's behind the scenes that you're not disclosing to everyone.
Right.
And yes, someone can take the screenshot and try to reverse engineer it, but those of us that know, right, it's not easy to just code it up. Oh, let's just get that going, right? And so you at least have this head start that Noah is talking about.
So we're encouraging you. All right, cool. Next question.
So it won't be our fault.
Okay, I think we have time for these last two questions, right? Where'd Devin go?
Yeah, she
Devin
said yes.
walked out. Cool. You first.
So how exactly do you copyright, like, the code of a game?
You file a copyright.
But you don't even have to do that. You just have to fix it. Save it. Save it. Did you save your code? I hope you saved your code. Oh my God. If you didn't save your code.
Did you back up your backup?
Here, we're switching roles. I'll give you a real answer. Oh my God. So right. I mean, as they said, when you create it, you have copyright on it. You can't sue anybody unless it's registered. The main point of having your copyright registered is you can sue people now. Trademarks, on the other hand, are just more powerful when you have them registered, but you can sue without a registered trademark.
Yeah.
But anyway, copywriting your code is, again, super simple. And if you go on the website, copyright.gov, incredibly simple. They want the first 10 pages and the last 10 pages of your code. And now, I am not a programmer, but I know that's not how code works. Don't tell them that. That's how it works for the most part.
Well, this allows you to keep your trade secret. So the one thing is, what Ryan's saying, they have these things called circulars. They're not circulars. They're like old school circulars when you pass these papers around.
Yeah.
But the big thing is you don't want to disclose the good stuff. Right, and so usually the first 10 pages and the last 10 pages aren't the good stuff. It's a bunch of definite, hashtag include whatever. I don't know.
He doesn't deal with that part. You do.
This shows how I could take his screenshots and I would have it ready in like a day.
Yeah. So that's how you protect it. Cool. We did it. And then my last question was over there. That guy.
Licensed content with the company
Right.
We'll throw Nintendo out as an example.
Okay.
How do you begin to discuss with the company about like engaging that gap as opposed to waiting for DCMA?
Right. So the question there is, if you are a maker who wants to work with a company, how do you go about doing it without, just waiting to get sued, which is what Ryan accidentally implied earlier. He's a good lawyer, guys.
Wait, for what?
So the answer is you cold call, you reach out, you hire a lawyer because we have contacts because we know the legal departments at these other places.
Well, don't overstep that though. I mean, it's the same as like if you are an esports player and you don't have an agent, you're probably not going to get on a team. If you want to go make a video game that Nintendo owns the IP, if you don't have an attorney who is, at 200 conventions a year with the attorney from Nintendo sharing a drink with them, they're not going to pick up your call.
No.
So, when Noah and I call Nintendo or Sega or whoever it is, we can at least have a conversation. I would say still 90 times out of 100, it's a no. But we bill very little to do that to our guys. I mean, very recently we just had that. Somebody paid us a retainer. I couldn't get what they wanted, and that's the end of it. But got a lot further into the conversation than they would have had emailing random marketing emails.
And so part of that is you're going to have to engage an attorney at some point anyways to review or write the license if you don't want to get completely steamrolled and sell your firstborn.
Yeah.
I don't know if you have a firstborn, but if you do, you will give it away inevitably.
Or you need to get one.
Yeah, you need to get one because the contract requires it. So
They're
get working.
so easy to get.
Yeah. What?
They're everywhere.
Oh, this
You talking
man's
about
getting into
stealing
something else. I think
babies?
it's 7.
Anyways.
In exchange for a Pac-Man license?
So might as well go ahead and just ask an attorney to help you there. I know that's not the best answer because lawyers are scary. We're not scary, but that's what we got for you. So,
Well, put yourself in their shoes, though, for real. Like, imagine how many emails and phone calls they get a day versus their buddy calling them. And that's what you need to look for.
I mean, I know we don't want to go over, but so typically, is it better to scale at least something up to get them enticed a little bit,
You're
as
gonna wanna
opposed
have
to saying,
something, yeah.
I've got this really cool game, it's all underwater.
That's such a good question, and it's such an unfortunate answer because, yes, if you don't have a really impressive demo or reel together, there is no conversation. If you go with a good idea, they're going to tell me just the same, go to hell.
I got you.
But you've wasted a lot of time if you get there. Now, again, not an artist, but a lot of those guys who don't get the yes can reskin their game into something else that's totally different, but same code, same underlying game, and that's what you see a lot of times. Yeah.
Cool.
Cool. All right, that's the time we have, guys. Thank you so much for coming.
Thank you.
Real quick, you can find Morrison at Morrison on Twitter. He's
I'm
also
not
a video game attorney on Reddit.
I'm not the Scottish Prime Minister or a food store.
You can find Chris Cotopia.
Australian.
I don't do anything on Twitter.
Yeah, don't look at him. But he's a great patent attorney and a great professor. And my name is
Do you have a
Noah Downs.
MySpace?
He does have a MySpace. I confirmed that before the panel. I didn't.
do.
So, and my
With
name is
a
Noah
geotech-
Downs, and I'm at my lawyer friend on Twitter. Thank you so much, guys.